Welcome to Court TV on Crestview Community TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today you're watching Jury Review. Now this is going to be a lot smaller docket than we're accustomed to, nowhere near the amount of people that you'll see at a pretrial conference or at a docket day. These are those cases that were left set for trial at docket day. There could be another case or two on there if there were some unusual circumstances or some small details to work out, but for the most part, these are the cases that are at the end. These were announced ready for trial, and that trial is going to begin next week on Monday morning when somebody's there picking a jury. Now, this date is really about scheduling for the next week for the jury trial, any last-minute motions that need to be done, motions in limine, things to exclude testimony or include testimony. Is there any information that's prejudicial to the defendant? These kind of things try to get ironed out at jury review. Now, after jury review, that's it. Monday morning, you show up, it's time to pick a jury and be ready to go. And you know, we always love to watch those jury trials here on Crestview Community TV.
For this morning, it seems to me that the most efficient way to try to handle, because we have a couple different kinds of cases this morning, is to do the non-jury review cases, the cases that are not anticipated to go to trial, to handle those first, get them out of the way. Not get them out of the way, but do what we need to do with them, because the other cases will take, or could take, a little bit longer. Certainly one of them will. So we'll skip over Coffin. And is Mr. Nopes here? Yes, sir. You're hiding back there. We're going to go with Collis.
Good morning, Your Honor.
Good morning.
I've got Mr. Collis's case, 21 CF 1512. Judge, I was able to go and meet with him yesterday afternoon at the jail. He's asked me to ask the court. He wants to demand a speedy trial. That's what he's asked me to ask the court.
Judge, I would ask that counsel file a formal pleading and go through the proper procedural steps. Set the calendar call. We have 60 days. Right? This gentleman FTA'd for almost a year.
He FTA'd September 2nd of last year, I believe, and he got rearrested July 25th.
FTA'd for a year. So this case has just come back on our docket. So I would ask that the formal pleading for demands for a speedy trial be filed, and then we take it from there and we can go through the proper process. And there will also be a failure to appear case that will be filed and opened. So we will also have that set on the docket as well. That will be a third-degree felony punishable by 5 years. And we can track that case with this case.
Mr. Nopes, does that sound like a reasonable? It sounds like no, sir. I'm not asking Mr. Nopes. Is that an appropriate procedure? I'm just talking procedure. I'll let you talk.
Judge, the state has every right if they want to file the failure to appear. That's true.
No. That's not my question. My question is as on the speedy trial. You need to file something and we'll go from there. That seems like I just want to deal with one thing at a time. So if a speedy trial is filed, then we'll proceed with that. And I wasn't actually addressing the failure to appear, Mr. Nopes. And the failure to appear, you are correct. The state, they want to file something, they have to file something. So that's not before the court at this point, but it might be in the future. So anything else that we need to deal with this morning, Mr.
Judge, I
Nopes,
just
on
want
this?
Mr. Collis to know that the state's offer was 60 days in jail and to take no action on the failure to appear, basically dismissing that failure to appear if he wanted to take that. These 60 days, I know he's been in for almost 30 at this point. So that was the state's offer, if you'd like to resolve both the FTA and the criminal case in court today.
Judge, just so I want to me and him had a long talk this afternoon, okay? We don't always agree on everything. However, he's 47 years old. I don't believe he's ever been arrested for a felony. I don't think. Having said that, if we would love to say, okay, we'll spend another few days in jail and we'll get out, but it makes him a convicted felon.
He's already has a possession of controlled substance in his.
Was he convicted?
I'm not sure.
Because he told me he's not a convicted felon. So, I mean,
We
that's
can
my-
determine that.
Yeah, I mean, so, and I asked him that. I said, if you were convicted in the past, that's, 1 versus 2 ain't going to change the world. But if you've never been convicted, 1 changes a lot.
Well, would it make sense then for us to determine whether or not that he's convicted, if that's we can hold on this just.
No, I object, Your Honor. I want to set it for trial.
But listen,
I'm not giving
We're
the
going to
state.
give you a chance to set it for trial.
He's going to set it
Got
for
the
trial
file?
ultimately, but let's find out if you're a convicted felon or not. Because that could change things. Pass it for a few minutes this morning, okay? I'm not trying to hurt you, I really am.
I'm really-
Okay.
You've been around.
All right,
I have you for your counsel for a reason, but I do want to set it for trial.
okay. We're going to bring you back out to do all that.
Mr. Nopes, the clerk, no way to verify. Do you have a case number?
I didn't hear the case.
18 CF 3314. Clerk, in reviewing the file, has indicated that they believe that there was a conviction,
Okay, I'll check
that
that.
there is a felon.
I'll check that. Just let's pass it for a few minutes this morning.
Okay, very good. Jernigan? Number 3, yes. Mariah Jernigan.
Judge, I'm here on behalf, Marty Nopes, on behalf of Mariah Jernigan in 19 CF 367. Judge, it is a violation of probation. We're asking the court to consider setting a bond. I understand that she appears to have violated her probation, but since she left the one treatment program, she's done a lot of things to help herself. I did a notice of filing on September 2nd, I believe, that showed that she's currently involved with Pathways.
What is the violation?
She absconded from her treatment center. She walked out of Phoenix House, one of the best free treatment centers in the state. And she absconded for several weeks or almost up to 2 months, and then turned herself into a different facility. And this would be, I think this is her second violation of probation. Her first violation was back in 2020
On the same case?
on this same case. So the state, of course, would be opposed to any bond.
Sorry, Mr. Nopes, I just wanted to get that as just from my information, and go ahead and tell me what you were.
So, Judge, just from the paperwork that I filed to the notice of filing, I think she showed up at Road to Recovery on June 7th of this year, and she was discharged from that program on August 7th of this year, having satisfactorily completed it. There were some other classes that she took during that process that she got certificates of completion for. Once she left that program, she's now enrolled in the Pathway Treatment Program out of Pensacola, and she's getting the help that she can get based on her resources and what have you. And I understand the state's not particularly happy with her leaving Phoenix House. But having said that, she stayed in contact. I believe you could ask Mr. Berry. I think she's been in constant contact with Mr. Berry to tell him, that she was going to come turn herself in, which she did, Judge. She talked to me probably a month ago, and the plan was for her to turn herself in and for me to be able to get a bond hearing set. And so that's how we got here today. So I'd ask the court to consider setting her a bond with the condition that she continue to her treatment with the Pathway program.
When she left Phoenix, when did she leave?
Your Honor, if I may, I believe it was
Please.
in March,
Okay.
and then she entered into the Lakeview Center in June, so there was a 3-month window right there. Quite honestly, I didn't know where she was because when I transferred her to Phoenix House assumed that supervision. However, when she did leave there, I have to be very honest with the court, she called me,
When she left?
Phoenix House.
Okay.
And she called me, she said, hey, I left Phoenix House, and I tried to say, well, you need to get back in there. And she couldn't, didn't, I don't know exactly what happened right there. But after she got in this program, every week, she's called me on the phone. The only thing I can
What
tell
program is she in? Was she,
the road recovery program and cold water.
that's an inpatient, correct?
That is correct. I have I mean, if the court wants to look at it, a letter from, I call it the road recovery program. Can I approach?
You may,
But it's actually the Lakeview Center.
Show it to Mr. Null. I just want to make sure the attorneys see it.
I think that-
Saw that.
None of these documents explain where she was for 3 months.
No, this,
Discharge from that program. Requirements of the program.
okay.
Mr. Berry, how long?
I'm sorry, I'm confused. I thought you said she was in the Road to Recovery program. She's finished that?
That was what, 2 months? 2-month program?
So what she just told me is the reason she didn't start Road to Recovery until June is there wasn't a bed available for her. She took,
Whatever, I'm trying to figure out where she's at now.
so what this letter says, Judge, and it kind of wraps it all together, is that Ms. Davenport's anticipated graduation date from the program, the Road to Recovery, is Thursday, August 4th of '22. She has confirmed her transition plan to maintain her progress in treatment after she graduates from the program. Her transition plan includes engaging in IOP at Pathway, which that's part of what I filed, continuing with the STOP program for the Vivitrol injection, going to NA and AA meetings, started working the 12 steps, obtain a sponsor, continued probation, and transition to sober living once legal obligations are taken care of. So I think there's a plan in place, and I think she's got a sponsor now.
Okay. I give you the final word.
Your Honor, this is her second violation of probation. She left one of the best free treatment programs in the state. My understanding is it was prior to her being kicked out. She disappears for 3 months, doesn't follow the procedures for probation, then resurfaces, then starts a different short-term program. She scores state prison for her latest violation of probation, and the state will be seeking the state prison sanction. We believe that she should remain in custody. This was a choice on her part to do everything that she has done, and it's her second violation of probation.
Okay. The question before the court today is whether or not there should be some type of a bond. The court's making no ruling. As a matter of fact, it sounds to me like there's a pretty good case for a potential violation that the state could pursue, but we're not here on that today. The fact of the matter is that the defendant, while she, I would assume, is staying sober while she's in jail, she's not getting any of the treatment that she would get if she was on the outside. The courts, the state has every right, and apparently are going to pursue the VOP, and they have every right to do that. Courts, I'm going to acknowledge the effort that's been made by the defendant. I'm going to give her a bond, and the state can pursue, and they may very well pursue the VOP. But I'm going to give you a bond and give you a chance to get back into counseling. If you're doing all the things that's stated in that letter in the follow-up program, then it's good. I don't know why you got out of Phoenix House. I do know that sometimes you got to fail a couple times on these road to recovery on addiction. And it sounds like you're making a good faith effort at this point. Again, doesn't keep the state from pursuing you, and they may very well have, it sounds like they may have a decent case. And that's fine, but I'm going to give you a bond today. So I'm going to give you a $500 cash or professional bond. But the conditions of that are all the things that are contained in that letter. All the follow-up programs, the Vivitrol, the AANNA meetings. Could you go over let me just make sure and get that letter, the things that she was doing as the follow. I want to put those as a condition of her release.
Well, Judge, I will tell you that if she is released on bond, she is still on supervision.
Right.
So if she will
That's right.
come to our office, we will assume the supervision
Absolutely.
and make her comply with all the terms and conditions set forth in the original probation/community control.
Right. But there specifically, there were a number of things that they said she was, the engaging in IOP, that's intensive outpatient, continuing the STOP program with the Vivitrol, going to NA and AA, and working on the 12 steps, obtaining a sponsor, and obviously continuing probation. That's continued. So those are all kind of conditioning your release. And ma'am, if it hasn't sunk in here, you're on kind of the last rope. So if there's a violation, you're probably going to end up waiting it out until it's resolved in jail.
Yes, sir.
Okay. Good. Yeah,
Got one more, Judge.
hold on a second. Do we need to do a court date for that one? Is there a VOP that's been filed?
Probably. We can deny the VOP. Then we'll just get a court date.
Sure, that's a good idea, and then we'll... You want to just come back on miscellaneous? You want to do it in the afternoon or do it in the morning and kind of see where we're going with it? If you're ready for, if you're wanting to go to an evidentiary, why don't we do it in the morning, see where we're at on the next miscellaneous, and then if we need to go to a hearing, we'll
How far away is that? Is that a month or?
Well, we've got a miscellaneous docket on the 29th of September in the morning.
It's pretty full if you want to do October 6th.
Okay, October 6th.
Judge, that'll be fine. I'm
Do
just.
that in the morning, come to see where we're at. There may be an agreement, that resolves the VOP. It might be, or the state can, then we'll tee up if we have to have an evidentiary, and we'll deal with that. Okay.
Okay.
So your last one is Mike Mandel?
Yes, sir.
Actually, your last one isn't because you still have to deal with Mr. Collis.
Right, exactly. All right, so Mr. Mandel, Judge, has, I think now, 3 cases with you, 22 CF 1320, 22 CF 1549, and 22 CF 2038. Originally, you had 2022 CF 1320 because it was a Crestview case, and they've got the other cases transferred up here now. So you've got all of them.
Okay.
So that's good news. Bad news is that when the state does the score sheet, he scores out to prison. And I think at this point, we need to say, put it on the next pretrial and let me get the discovery.
Okay.
Because of the-
So we'll
the score
continue
sheet issue.
until October 26th.
Very good, Judge.
Okay.
I'm going to go talk to Mr. Collis, Judge.
Very good. Hughes, Mr. Moore?
Your Honor, we're not, Bert Moore for James Hughes, Your Honor. We're not going to be able to enter a plea today, Your Honor. Mr. Hughes has requested that I file a written waiver of jury trial, which I will do. But I have been instructed by the state that they will object to that at this time.
Your Honor, first of all, Mr. Hughes apparently thinks this is all a big game. He is now turning down the 20-year offer that he made to us, that we had cleared for him. I understand that is his right, certainly. But from this point forward, there will be no more negotiations. He is facing life in prison without parole if convicted on one case, minimum mandatory of 25 to life on the second case, and the state was ready to proceed with the next trial cycle. We asked to be first up. There will be no further negotiations, and we ask there be no further continuances. As far as the judge trial, at this time, Your Honor, we'd like to reserve the right to decide whether or not we would object, and we'd ask to address that with the court later on once we review everything, but we will be prepared to proceed.
You have the right to file it, Mr. Moore. You have the right to object.
Thank you, Your
That's
Honor.
not before the court today, although I appreciate you, kind of alerting the court that that might be coming, but we'll deal with it in due course. We'll go ahead and continue this till October 26th. That's our next cycle. And are you ready for trial, Mr. Moore?
Yes, sir.
Okay. Just wanted to make sure the state saying this, they wanted this to be the last continuance. I wanted to get a concurrence out of you if that's your position. So we'll be ready to go.
I don't think there's...
How long do you think, how long of a case?
Okay.
Your Honor, 1 to 2 days. There will be some motions we'll need to address, so the state will get those filed so that we can address those on a motion docket prior to that and be ready to go on that date.
That'd be preferable, certainly, for the court.
Yes, sir, they're Williams rules, and so that will take a little time.
Rule, child hearsay, things like that, Your Honor.
Sure. Very important.
Your Honor, could I speak, please?
Your Honor, I've advised Mr. Hughes not to speak to the court today. I advised him Tuesday not to do the same.
Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You understand that this is being recorded, anything you say can and will be used against you in a court of law?
Yes, sir.
You may address the court.
Your Honor, on May the 26th, I signed a plea deal for 13 years DOC, 10 years probation. Mr. Moore gave it to Ms. Christine. Well, we came back, and he said, well, we're going to go before the judge with
I
it.
don't know if we can discuss pleading.
Mr. Hughes, whatever you want, let me just be completely
Yes,
honest
sir.
with you. Anything you did in your negotiations with your attorney and the state, that's up to you all. I'm not in the middle of your negotiations.
Yes.
Even if you said something and appeared to negotiate, I don't even have any say in that.
Yes.
I'm not a mediator. I'm a judge. All I can do, if you file a plea agreement, I'll consider the plea agreement, and more likely than not, most of the plea agreements I accept. That's my only role.
Yes, sir.
I don't get in the middle of the negotiations.
Well, I'm not the one that's just continue wasting your time or the court's time.
No,
I've been ready to,
So you're not wasting our time. You have a constitutional right to go to trial.
I've
The
agreed
state
upon.
has a constitutional right to pursue all the remedies they have under the statutes of the state of Florida.
Yes, sir.
That's kind of where we're at.
I've agreed on like 2 or 3 different plea deals, and when I come to court, it's oh, we're going to continue it. And I just don't feel like it's right to just continue.
Okay. Again, I can't get in the middle of it,
I understand that.
so.
But I just want
It'll
to.
be the last one that's continued, because everyone's saying they're ready to go, so I'm ready too. Okay, thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Is Mr. Powell here? Is St. Ange? Was
Your Honor, I spoke to Mr. Powell yesterday afternoon. He did have an appointment he couldn't miss. He asked if the court could just pass this. I believe we're going to have a plea.
Okay.
He did ask if we could
That's
pass it a
fine.
little later.
That's fine. David Russell? That's a...
Your Honor, Tim Gibbs on behalf of David Russell, 21 CF 2535. We had set it today from yesterday to see if we were able to resolve it. At this time, we aren't. We'd like to continue this to next cycle.
Very good. Continue to October 24th,
Wait,
9
no,
a.m.
that is absolutely not what I said.
I'm sorry, what did you want to do, sir?
I have been ready for October 2nd of 2021.
No. You're saying the same thing. You're misunderstanding what he's saying.
I'm sorry, yeah, I'm sorry.
We're gearing up right now for trials next week. This is not right for that being ready for next week. So the next cycle is October 24th. So you're up next, and you want to go to trial? The state will accommodate you. You have an absolute constitutional right to go to trial and to defend yourself.
And we'll talk more in the meantime on what we
I'm
want to do.
not-
for
So we're
starting.
continuing to October 24th.
Do you want to represent yourself?
I'm going to be completely honest with you, the state's not ready for the trial. They never have
Okay.
been, and they never will be.
Okay, well, good.
Speak in the meantime.
Very good.
Thank you, Commissioner.
October 24th?
October 24th, 9 a.m.
Thank you.
Other than the Collis case and the St. Ange, I think the only cases we have are the trial cases.
What is Otis?
I'm sorry?
Your Honor, there was one addition, Mr. Terry. It's a VOP in a bond. I don't know exactly which docket that
I believe
lands
that's
on.
on the afternoon docket.
Okay, I wasn't sure. So
I think I saw some additions, is that, is that on the, pardon? 2 o'clock docket, okay, thank you.
Thank you, Judge.
Okay. Let's try and do Billabong, because there is that's one of the ready for trial, but there was some question of possible Nelson hearing.
I think we need to make the record clear on that, Your Honor. Your Honor, Tim Gibbs for Casey Etheridge on behalf of Mr. Michael Bullabaugh, 21 CF 2621, 21 CF 2633. I believe last time we were in court, Mr. Bullabaugh had indicated that he would like a different attorney. He did not like or did not appreciate the work that Ms. Casey Etheridge had done or not done. I believe we need to clear the record and make sure if he would like a Nelson hearing that we can set that and get those allegations prepared, and he can, of course, write his allegations for the court.
Are you wanting to have a new attorney, Mr. Bullabaugh? Okay. So what you need to do is you need to file sometime. Okay, hold on a sec. Hold on a sec. Clerk? I'm looking at the first case, 2621. I don't see any filing. So has it been filed with the clerk? What'd you do with it? Okay, so you've submitted it, okay. So let's assume that it's coming in, then the state will see what, not the state, your council, what's going to happen is we have to have a hearing on it. It's called a Nelson hearing. That's based on a case that the whole thing is, listen to me. It's not just a simple issue, okay? You've got to, because we have to determine, and the defense has to have an opportunity, the defense counsel has an opportunity to respond to it. Here's the deal. If there's a reason, and that's what the hearing is about, then you would get a new hearing, then you would get a new attorney. If there's not a legitimate basis, then you don't automatically get another attorney. So then you got to look at it. So we've got a formal hearing, okay?
Mr. Bulaba, that would be a question for your attorney.
This is about your attorney.
Question, but have they been getting answered? Not every question I've ever asked has gotten answered.
Okay,
My case is 33 years old, man.
okay. So, let's come back on, let's assume he's got it, and where are we at on October 6th? Afternoon, or September 29th in the afternoon? Yeah.
If it'll help the cool in, let's go ahead
October
and get it
6th.
for trial, because I can get a better situation in the Court of Appeals. Let's go ahead and get this scheduled for trial, let's go ahead and get it in the Court of Appeals. Because I know they'll overturn this. I
take
already
what-
know this lady here, I don't know what she thinks she's doing, but I've had enough of this, man.
Okay. We'll come back October 6th in the afternoon for a Nelson hearing. Thank you. Okay. So that leaves us with the three remaining cases and then Mr. Knope's case and Mr. Powell's case. We'll deal with those when they come. So let's go ahead and, Mr. Johnson, you can come forward for Alex Coffin. Coffin.
Here, President Courtroom, Your Honor. We're ready for trial. We talked about, I understand the court only has one trial week now, which is next week. Talked to the state. We have looked at, I indicated I'm available on Thursday and Friday to try the case. I don't know how the court does jury selection here, if you're picking and going on the
Pick and
same.
go.
Pick and go.
On these cases, we'll pick and go.
Okay. I think we're talking to the state that Friday probably is the best day that works for both of us if the court.
Thursday. Between Thursday and Friday, Thursday is the only we've got. Got
Judge-
4 days.
Oh, okay.
Judge, I have court in front of Judge Brown, including a sentencing. But that's the only day I'm unavailable next week.
Well, We've got trial day, yeah, I mean, I understand that there are cases that you can't do, but there are situations that the court can't. So we've got 4 days to choose from. If we don't, we're going to have to push it. I want to do it.
Tuesday and Wednesday, I've got those.
What about Monday?
Monday, Judge Brown has set the pretrial detention hearing in the one that Your Honor Mr. Howard's case. It was originally set for this afternoon, then it got pushed to Monday, and it's a Zoom in, and he'll take it whenever he gets a break from his 511 pretrial day, or pretrial days. So I don't know when that's going. I talked to the state about that, or Michelle Sandler, and that's, we both agree it has to, technically it's supposed to be done within 10 days, and we're kind of pushing the limit there at that point, so.
It's highly unusual on the court's part, so, I mean, it probably
I understand
happen in another year if we had these things.
Let me make a call or two, Your Honor, and just see. The reason, and I've talked to Sandra, I've got some civil, Santa Rosa County, but the problem is that there are family law things that are set on the docket, and with the backlog over there, if I cancel a hearing, I'm looking at July or August of next year to get a new hearing because they're not setting anything even into next year just yet at this point. That's not this court's problem, I understand, but
But all of these are the same issue, and they're not anybody's fault. They're based on backlogs that we, starting with here, and I know my division, the folks, everybody in this room included, have worked very hard to unclog the criminal, but it's not anybody's fault.
And Judge Miller had indicated, thank goodness, that after we move into the new courthouse over in Santa Rosa, they are going to start putting some senior judges over to try and get some of this backlog down, but that has yet to happen, obviously.
It sounds bad.
It is. Give me a few, if you don't mind, let me make a few phone calls, see if I can do something, and then I'll talk to the state and we'll bring it back up.
And perhaps as far as scheduling goes, if we can have the last few cases that are set for trial be in front of Your Honor, and then figure out how many we have left and get through more scheduling that way.
Okay.
Thank you, Your Honor.
Sounds good. So, McQueen?
Your Honor, Tim Gibbs for Charles Russell, on behalf of David McQueen, 21 CF 1989. Mr. McQueen was set for today from Tuesday in the hopes that Mr. Russell would be back and potentially be able to either resolve the case. Since Mr. Russell is still out with his injury, we're not sure that, of course, that would be able to happen. We otherwise would request to continue this so that Mr. Russell can come back and work on this case.
Does the defendant wish, or the defense wish the offer to remain open until Mr. Russell has a chance to speak with him?
I would very much appreciate that, yes.
I will do that then.
Okay.
Not taken, then ready for trial next time?
I'm not going to speak for Mr. Russell on that, but that's
He's ready for trial this time, so I'm assuming he's going to be ready for trial next time.
You can handle it that way, Judge. I'd like to do that so that we can be on the trial docket if we need it. We can go next week, but
I'm not sure if Mr. Russell will be back.
You don't know what, you don't have a...
I don't have a set date when he is for sure to return at this point, Your Honor. That's just the frustrating situation that we're in on that.
Okay. Very good. So we'll continue the next cycle, October 26th for the November cycle.
trial if no plea.
And we'll announce last continuance on both sides, because we're ready now, so.
We are, yeah.
Where's Mr. Nopes?
Miller?
Nopes, no, his client was standing in the hallway, and I thought he was talking with him. If we find Mr. Nopes. There he is. Are you ready for your call us, Mr. Nopes?
I think I am, Judge. Judge, on Mr. Collis's case,
It's 21 CF 1512.
Judge, the state has extended an offer to allow him to plead to misdemeanor petty theft with an adjudication of guilt in 60 days in the county jail. I've talked to him about that, and he insists that he doesn't want to accept that he wants me to ask the state to simply dismiss the case.
Put this void on his face.
His position is void on its face. I don't agree with that position, Judge.
So let me explain. I assume the state, what's the state's position, just for the record?
On the dismissal.
Yeah, you made the offer, he's counter-offering you in court here, and I'm just asking before I kind of explain where we're going, I need to know officially where you're at.
The state would reject that counteroffer.
Okay. So what we will do, what needs to happen, or what we're going to do is we're going to continue this case here today and get it ready for a trial. You're going to end up being in jail longer than the offer. But if you want to do that, you're welcome to do that. So anyway. So, and if you wish to file a speedy trial, you can do that, but that's not going to, those numbers don't add up for you, but I can't force you to do anything, and I don't want to force you to do. I'm only here to protect your legal rights, and I will do that.
I told my attorney that I would accept the conditions if I could reserve the right to appeal the decision. He told me that, I don't think they would go for that. You know what I
Judge,
mean?
time out. I did not tell him any such of that in that room in there. So
Do we have microphones in there?
I did not say that to him. I did not.
I'm going on the oath and affirmation that this is what this man has told me.
Judge, I need to withdraw.
I said I would accept the charge, I would accept the state's offer if I could retain the right to appeal the decision. I have that right.
Judge, he has that right. Why would I tell him he didn't have that right?
Well, state, I accept.
Hold on a second. Is the offer still open?
He wants to plead to an adjudication of guilt, petty theft, 60 days, court cost of prosecution. Today, I will let you do that. Everyone has the right to appeal. You have 30 days to appeal if you'd like, but this is the offer today. And you also have failure to
With the
appear.
credit, I will be out in 5 days. Yes, I will take that offer, and I will appeal it at my own convenience.
The jail is in charge of the credit, but you
Yes,
should be
ma'am.
given credit from the date that you were arrested on this case.
Well, I accept.
Okay. And that's a misdemeanor?
Yes, sir.
Okay. Would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, and nothing but the truth, so help you God?
My soul.
So you just want to make clear that what the offer is, 60 days, county jail, credit for time served, plus to a lesser included, and what's the charge?
Petty theft.
Okay. What I would ask is that, just to try and, because it's a misdemeanor, we don't technically have to have a written plea, but I just want to make sure we're clear about it so we don't, do we need to do that and come back, or can we?
It would be first-degree petty theft. I can draw up a plea form for Mr. Collis.
But I've got one filled out.
Okay.
But
Go ahead and get him to sign it. So we just want to make sure and get it in writing.
lesser included offense of petty theft. The maximum you could get is a 1 year and $1,000 fine. There's no minimum mandatory adjudication of guilt, 60 days Okaloosa County Jail with credit for time served. It's up to the judge to decide court cost and up to the judge to decide if there's any state court-appointed legal assistance fees assessed.
I have one question before I sign this. She said that the court costs and all that, do I have to pay that today?
No.
We'll
give you, how long do you want to pay it? 120 days, 180 days?
I'm homeless,
I'll give you,
unemployed.
we'll do 180 days, and at the end of that, it just goes to collections. How about that?
I can agree to that, sir.
Okay, good.
Right there. dated 9/8. Today's the 8th of September.
You may. Thank you. Okay, Mr. Collis, based upon this plea and sentencing agreement that you have signed and your statements to the court that you're in agreement with this plea, court finds that the plea is free and voluntary, and there'll be an adjudication of guilt. You'll be sentenced to 60 days in the county jail. You'll get credit for all time served. And then the standard court costs, what are the court costs in legal defense fees? $150 for legal defense?
And then $270.
$270, and you'll have 180 days to pay, and then it'll go to collections.
One other question.
No.
Can I have a copy of that?
Yep.
That agreement?
Yep, No, I want to file it. I want you to just put in the fees, and it'll go to collections in 180 days.
Is the state
So
taking
two-
action on the FDA? What now?
FTA?
No action.
No action on the, put that in there, no action on the FTA. So the failure to appear, the state's not taking any action on.
Have a copy of that agreement, sir.
Yeah, I mean,
You can request it from the clerk's page or
yeah,
public records
it's
request.
it'll be filed, I'm giving her the original, it'll be filed, and then you can get a copy of that from the clerk.
We can now give you a copy of it.
Okay? Thank you very much, sir.
Thank you, sir.
Mr. Johnson, I'm sorry, go ahead.
Approach Austin. This is well, that's 8.
Mr. Johnson, any,
If I may, I've made a couple of phone calls to try and see. I didn't get anybody nobody's willing to agree to anything as far as my, moving things. If the court were going, I am aware that there's judicial rule of administration that says that criminal cases do take precedence. So if the court order be to set it for next week, I would ask that it did set it on Wednesday, and then I'd just have to file a motion for continuance in the other case. And I imagine they grant it because I'd cite the rule, but they're not, I'm going to have some very unhappy clients and opposing parties in the case, but it is what it is. I mean, the court, I leave it up to the court at that point, because I can do Friday. I know the court can't do Friday, state can't do Thursday, and my
What are you
Tuesday.
doing on Thursday?
I have Judge Brown, I have sentencings and some other motions in the morning and afternoon.
Okay.
Not trying to be difficult, Your Honor, I promise.
No, nobody's, we're all just trying to get it done. We're all
Yes,
in
sir.
the exact same situation. It's not her fault, it's not your fault.
Yes, sir.
Not my fault.
No, sir. No,
If
sir.
anybody, it might even be my fault. But, okay, let's set it for Wednesday then. And I think when we talked about this, we anticipated it being a one-day.
Yes, sir. Yes, Your Honor.
So let's just kind of go over a couple of the standard things. Are we, hold on. We've got some of the preliminary, I see you guys, got some of the preliminary jury instructions.
Yes, Judge, and
I
I know,
appreciate you getting those to me.
would you like me to leave the numbers in until the very end and then take them out? I know that could be confusing to the jurors if we keep the numbers at the very front of each page.
What do you mean, the numbers?
2.1 for jury instructions, 2.7 for closings.
Right,
all
right,
those-
right, right.
Okay.
Yeah, just removing them, I guess, right before they go to the jury, so that they
Yes.
don't wonder where the missing numbers are.
Yes.
Sure. And do we have any, have witness lists been exchanged? Hold on a second, let me pull up the case.
And Judge, we haven't submitted a witness list. At most, we expect 2 law enforcement officers to testify. We haven't submitted a formal witness list, but at most, we expect those 2 law enforcement.
Right. And I don't have anybody that the state has not already previously given me, or that hasn't been deposed, so I don't think it'll be.
Are you going to formally file something?
Sure, Judge.
Okay. And do you anticipate having any exhibits?
Yes, Your Honor, we do.
We filed a notice of intent to rely on certified records, and that's in the court file.
Has that already been filed? That's what I
Yes,
was-
Your Honor.
Yes, Your Honor.
Okay. At this point, there's no objections on those?
No, Your Honor.
Okay. Is that the only exhibits that you anticipate?
It will depend, Your Honor, I think, upon whether or not my client, I've discussed this because the state brought it up, whether we're going to stipulate to his status as a registered sex offender to eliminate that. But if not, then of course there might be some additional exhibit that's needed. I will let the state know that by first of next week, because we're going to discuss that.
Okay. So I anticipate we'll, like I said, we'll be doing a quote, pick and go. It sounds informal. We'll pick the jury and proceed immediately. What do you anticipate, or what would you request as far as the number of jurors? I mean, I know we have kind of standard thing. I just want to make sure if there's anything particular about this type of case that might.
That it does involve at least tangentially the sex offense.
I think 50 or 60 would be fine. We should be able to get, I'd say 60 just to be on the
60 would be
safe side,
safe.
because anytime I've picked for any of these or any cap sex bats or anything, there's always just a lot of people that
Right.
don't want to sit. They hear that and they're immediately.
Sure.
60, please.
Okay. So any other motions that are anticipated, motions?
No, Your Honor, that
Motions
nine
in limine, obviously, that's kind of what we're looking at.
I don't believe we have any at this point, Your Honor.
Any anticipated evidentiary issues? This looks like pretty straightforward.
I think it is, Your
case.
Honor.
Okay. Okay, so we'll reconvene at 8:30 on Wednesday. We'll probably have the jurors report at 9, so, if there's any last minute, anything procedurally at the last minute.
Your Honor.
And so, it's important, Mr. Coffin, that, with these kind of, even these procedural hearings, when we're at this stage, that, that you are actively involved, so you can ask your attorney any questions.
Yes, sir, I am.
That what you're doing and whatnot. Do you have any questions about how we're proceeding here today?
No.
Okay. Just want to make sure that, we're kind of talking with lawyers. I want you to understand that we're here because of you and that you have a right, and my job is to be an arbiter, I'm not picking sides. So I'm here to protect the rights of both sides. So that's my goal here today.
And Your Honor, just to clarify for the record, the state had originally filed in June of 2021 information alleging 3 counts of failure to register. However, the state filed an amended information August 18, 22, alleging only 2 failures to register counts, and we will only be going forward on 2 counts.
Okay. Were you aware of that?
Yes, Your Honor, I was.
Okay, and I think we withdrew the plea offer at the docket stage, right?
There was never a plea offer particularly as to this case. The only plea offer we had was a joint plea offer with the other case that is pending that was continued.
Okay, very good. Anything further that we need to do here today?
No, Your Honor.
No, Your Honor. I will submit a witness and exhibit list to the court.
Very good. Thank you very much.
Thank you, Judge.
Okay, let's, we've got the,
Your Honor, I just also have Mr. Larry Miller for this morning. He's here this morning. I know he has some motions this afternoon as well.
I
Some of
thought
those.
the motions were this morning. We're doing Larry Jack Miller?
We thought that they were this afternoon, but at this point, I think we need to find out if the defense is ready to proceed. Mr. Russell's not here.
Since Mr. Russell's not here and I am not familiar enough with this case, I don't believe that I would be effective if I were to try to argue any of these motions. So we'd have to set them for a new date.
But you don't know, you don't know when?
I don't know for sure if he'll be here Monday. I don't know for sure if he'll be here tomorrow. Unfortunately, due to his injury, it's not the most concrete on when he'll return.
Well, we have a Wednesday date that's been filled. I suggest that we try to proceed with what we can here today, set it for Thursday, and try to see if we can get Mr. Russell here on Monday or Tuesday to do these motions. Anyway, I'm open for suggestions.
Your Honor.
I don't want to push it again. I don't think he
I
wants
understand that
to get this
situation, too.
resolved as well.
Yes.
Your Honor, I would agree that we would like to get it resolved. On Thursday, I do have a 3850, attorneys, et cetera, et cetera. Certainly, I could try to move that if possible. My other concern, though, is for Thursday, that the mother of one of my child witnesses has surgery that day, and that's something she can't move.
So why don't we say we'll schedule it for Tuesday? Maybe, we'll, why don't we set the motion hearings for like Monday afternoon? And by that time, he's got to be in communication by phone, so you're going to have to give us the definite. Obviously, if he's not here on Monday to do it, then I don't know what we're going to do. I mean, the one thing, probably the only thing that we could push this trial would be a legitimate health issue for one of the attorneys. And that's what we're facing. It's not
I don't know if Monday's kind of late for everybody to be, I mean, we can do whatever the court wishes us to do, but these hearings, I do need to have at least one witness for these hearings. It's a child witness, mother has to take off work.
You're talking about for
It's for the Williams rule hearing.
Right.
And so, she's already taken off work today. She'd have to take off work again Monday if we do our motions Monday. If there's any way we could know before Monday if we're actually going to do it on Monday,
Sure.
that's all I'm asking.
I'll certainly be in touch with Mr. Russell, and he can inform the court and Ms. Basso.
So you tell me when it would be most convenient to set it on Monday, and then we can, if we'll just have a telephone conference Monday morning with the attorneys, and just, are we going to go or not go, and I'll let the clerk know if we're not going to go for Monday.
And if we could do Monday afternoon, Your Honor, that would be great. Or as if we're going to do the motions.
Okay.
We certainly need to get all these done before we even think about picking a jury.
Absolutely. They're very important. I was reviewing them again this morning, so, these are substantive hearings that will certainly impact the trial.
Your Honor, just
Go ahead.
planning purposes, then we would do any motions, if we're a go, and Mr. Russell's available, then we do the motions on Monday afternoon, hopefully, pick our jury Tuesday, and then roll right into the trial. So if they can go on Tuesday, would that be the court's plan?
That's what I would think.
Okay,
That'd
that'd
be
be fine.
the only way to.
It will
get-
run most likely into Wednesday, just for planning purposes, because I think our portion of it would realistically be a day of witnesses and testimony, as I'm guessing Mr. Russell might want to cross-examine.
We got a trial on Wednesday.
Won't finish on Tuesday, I know that, Judge. If we're picking a jury on Tuesday, there's no way we can pick, go, and be done. So testimony,
What are we going to do? We just scheduled the hearing, just scheduled the trial on Wednesday.
Yeah, there's already a trial on Wednesday.
What's that?
Yes, there's already a trial on
I
Wednesday.
forgot that was set, I'm sorry. I was
Yes.
Zoned out looking at
Mr.
my
Johnson
stuff.
had scheduled his trial for
Can
Wednesday.
you come back on Thursday? Is that the one you said was a 3850 that you had?
38:50 in the afternoon. I can look and see if Judge Brown will let me move it all. Maybe he has a little wiggle room for me, I'll ask. Say
We can
no.
come back, we can come and start Tuesday. This is a big if.
And
Mr.
come back
Russell
on
got
Thursday
it.
morning, then maybe.
I'm sorry?
We could start Tuesday, get as far as we can, and then plan on coming back on Thursday morning, and I'll just try to move my stuff.
You might be done by the afternoon.
But I'll try to move my stuff too, if we need to.
Okay.
I'll at least inquire of Judge Brown and see what he
Let's
says.
try and say Tuesday and then Thursday. Yeah. How many jurors would you suggest?
60 to 70, Your Honor, it's a capital sex bat. We're going to be asking if we could pick our 6 plus maybe 2 alternates, just in case.
I'm not sure if Mr. Russell's going to want more than that.
We can usually get out of 70, we usually
Get a 6.
Can you be in communication with Mr. Russell?
Certainly.
Okay, so why don't we set it at 70? Unless you call my office, by mid-afternoon today when we're going to put in the official request. Okay?
And I'll be in touch with Mr. Russell certainly
If he
today
just,
as well.
if he needs a little more, then maybe that's the only thing. You're saying that you think he might require.
I'm not sure he may, and I'll certainly be in touch with him, and he can express that concern if he'd like to request more.
Just let us know this afternoon, so.
Yes, of course.
We'll come back early in the afternoon if we have to have any further discussion on, we're going to be in all afternoon today, so.
Your Honor, may I excuse my witness for this afternoon, then?
Absolutely. You want to try and deal with anything else here today as far as, got these motions? Are we good with, I know there was one question on one of the motions in limine on an exhibit, but the other exhibits have been, exchanged. I don't think there are any exhibits other than the
I think it's just the photos we were talking about.
Those are the only.
That'll be a brief argument, one way or the other.
Yeah, or any other,
I'm not aware of any other motions except for what has been filed.
not the motion, but any other issues with regards to any other exhibits? Have you filed your exhibits?
Not that I'm aware. I will certainly be in touch with Mr. Russell on that. I'm not sure
Okay, so
what all has been
What
filed.
we're going to have to do, I see just, I don't want to get caught up in the not being prepared. I'm not going to, I think, if we have the hearing on Monday afternoon, we'll basically do a little bit of a jury review. We'll go over some things.
Jury instructions and
As far
everything.
as any last minute, normally we wouldn't want to do it the day before, but, if we have any last minute, the jury instructions, any exhibits, just simple procedural stuff. The motions have all been filed. Those are the big things. The motions have been filed for some time, and those will be heard, and we'll have plenty of time to do that on Monday afternoon.
Previously provided a set of proposed jury instructions. Do you wish me to just resend those to everybody, or just, I'll reach out and see if Mr. Russell had any changes. I don't think he did.
Yeah.
I'll confirm with him.
And I'll prepare one for the Williams rule in the event that the court does grant it. I'll send the proposed one of that over to you.
Right. And there was one issue of a possible need for a therapy dog.
Yes, Your Honor.
That's all right. I don't know, if somebody must have told Eileen because she gave me a note, which is about the only way I would remember it.
Our victims are requesting that they be allowed to have one of our therapy dogs. She is certified, her handler is certified. She has appeared before, not this court, but in this courthouse before.
I'm well aware of them. I haven't had the occasion to use them frequently, but I'm well aware of them. So they're beneficial for all involved. Anything else that we need to deal with today? Again, anything that's not dealt with today on a procedural matter, we can deal with Monday afternoon. But
Certainly.
anything today?
Not that I have right now, Your Honor.
Okay. So we will excuse, obviously, any of your witnesses.
Double check everything with Mr. Russell as well to make sure that we're all on the same page.
I'll be in contact as soon as we're finished to make sure if there's anything else.
Do you have any questions
Do you have any questions, Mr. Miller?
for the defense? So as you heard me say to the last defendant, we're talking to the lawyers and whatnot, but it's important that you're here and that you have the ability to ask any questions of your attorney, et cetera, because this is about you. So that's why it's actually required that the defendant be involved in these, so you understand exactly what's going on and you can ensure that your constitutional rights are protected. Okay?
Thank you, Your Honor.
Thank you. Okay, so we will reconvene at 1:30 this afternoon.
Mr. Hughes back on the transport for 2.
Sure.
Thank you.
Well, Is there a reason?
I anticipate a plea, Your Honor.
Okay.
Now,
I assume the state wouldn't object. I don't know, how did we leave it? Was it withdrawn?
I think we were done playing games, Your Honor. Mr.
I
Hughes
mean,
keeps playing games.
if it was withdrawn, do we want to bring him over? Is it withdrawn? Is the plea open?
Your Honor, I know the victim needs to be present if there's a plea. So I'm I don't know that I'm inclined to leave it open. Every time he shows up, he changes his mind. So I don't
Yeah, if I can
feel like
get-
that's a bad precedent.
If I can get a written plea to the terms, could I then put it back on it too?
Not unless the victims who have a right to be there, if they want to
I will let them know the status, Your Honor, as soon as we break for the morning. If
be in communication with
I just didn't-
Sal, and if you all can get it, I'm going to be here.
we will be here too, so.
And you're, I'm not opposed to doing it, but it's as long as there is a plea agreement, and that's up to you two, not up to me.
Yes, sir.
Okay.
Just as long as I wasn't foreclosed by the court.
No.
Thank you. That's really
Okay.
I guess that's really the request I made, Your Honor.
Okay, very good.
Thank you.
So we'll see it, reconvene at 1:30. So somebody needs to let the bailiffs know if he needs to be transported.
And I will do that, Your Honor.
Okay. Is that good? Mr. Moore, Ms. Bussett, they've ordered him to come back, not ordered him, he's been ordered to be, he'll be transported unless one of you all inform them by 1:30 that we don't need him. So he's coming unless you tell him, and if either one of you call, let him know, no, don't need him.
Your Honor, that would then be addressed approximately 2 o'clock after we get done with our other stuff?
Yes,
Just for purposes if we do.
sure.
Thank you, Your Honor.